Good morning, and thank you for investing your time with us today. My name is Effie Jackson. I'm with Equifax's Enterprise Risk and Compliance team, and I'm also an ACE board member. On behalf of ACE Roundtable, I want to welcome you to this session, Data Privacy Update on Cybersecurity and Privacy Priorities. And let's start by introducing you to our moderator, Elizabeth Bess Hinson. As chair of the Cybersecurity and Privacy Practice at Morris, Manning & Martin LLP, her primary areas of concentration include cyber and data risk management and governance, breach preparedness and response, crisis management, and global data privacy compliance. Bess represents clients at all stages of incident response, from investigation, notification, remediation, managing privacy class action risks, and defensive litigation and regulatory inquiry. She regularly counsels clients on cross-border data flows and navigating conflicts between foreign policy laws and U.S. compliance obligations. She oversees and coordinates EU General Data Protection Regulation compliance assessment and implementation programs for clients. Bess is the founder of the Atlanta Women in Cybersecurity Roundtable and holds many positions in the industry, including memberships with the Young Women Leaders Forum of Atlanta and the American Young Lawyers Editorial Board. I'm going to pass it on to Bess now, who will kick off the session for us. I think you're on mute, Bess.
I think you're still muted. Yep.
All right.
Good
morning. Okay. Thank you so much, Effie, for that introduction. I've just shared my screen, and I want to make sure that everyone can see the first slide, which reads, which is the title slide.
Yes.
Okay, great. All right. Well, before we get started, I have a few panelists to introduce that are here with me today for our session, which addresses how the EU-US Privacy Shield invalidation and the global pandemic are impacting cybersecurity and privacy compliance priorities. So I have here with me Faith Myers, who is Privacy Officer and Vice President of Global Privacy at the McKesson Corporation. She leads the Privacy Office, which is responsible for overseeing enterprise privacy compliance and providing legal advice and counsel to internal clients on data privacy and related issues at the state, federal, and international level. Prior to joining McKesson, she served as Chief Counsel, or not prior to joining McKesson, but she previously served as Chief Counsel within the Regulatory Operations Office and Division of McKesson Corporation. And prior to joining McKesson, she was in private legal practice, practicing at Alston & Bird, Smith, Gambrell & Russell, as well as serving as an Associate General Counsel at Emory University before joining McKesson. We also have Susan Lamb, who is here with us today, and she is Vice President of Risk, Security, and Compliance at Fiserv. Susan is a multidisciplined senior technology and security leader with a proven track record for developing and leading strategic security initiatives and innovations in fast-paced and dynamic environments. Prior to joining Fiserv, she served as Vice President of Global Security at Equifax, and she received several degrees, one of which was from the University of Hawaii and another at the MIT Sloan School of Management, and has various security certifications. We're also joined this morning by Karen Schuler, who is a partner in the Governance, Risk, and Compliance National Practice at BDO, and she leads that practice. Karen has really worked in this area for over 30 years, and she has experience building and managing organizations' data protection programs, digital forensics initiatives, leading cyber investigations, managing e-discovery, and providing data breach notification services to clients, and really just has incredible subject matter expertise to offer to us today. Prior to joining BDO, she founded one of the first digital forensic consulting firms in the U.S. and also served as a senior forensics examiner for the Security and Exchange Commission. So she has also serves as a data protection officer for Fortune 50 companies, and we're really looking forward to learning from her expertise today as well. So during our discussion today, we have several learning objectives and topics that we will cover to make sure that we get in our learning objectives. We will be providing a survey and overview of some of the changes and amendments that we've seen to international and U.S. federal and state privacy and information security statutes this year. We are going to be analyzing and talking about various data protection authorities guidance that has revised and reinforced existing legal requirements in response to the COVID-19 pandemic. And we'll also review the changes to the legal transfer mechanism, which has resulted from the European Court of Justice opinion and the Schrems II decision. So before we get started, I know we have quite a large number of individuals in the audience, and you all come from different industries and backgrounds. And so we would like for you to take a poll, and I believe that poll should pop up right now, and let us know which industry you're a part of, whether it's financial services or the healthcare sector and others, so that we can make sure the discussion focuses on concerns that you might have within your organization. I'm going to see, is that poll set up? If not, we can move on.
Yeah, maybe go ahead and move on. I think we're having a slight technical issue, here in our Zoom world.
Okay.
But we'll see if we can get that loaded up. Sorry about that.
Okay, no problem. So we'll just assume that you're working in a variety of industries, and of course we will take questions at the end. So please feel free to submit those questions, and we will answer specific to your industry. So let's start with. I'm going to move the slides forward. Oh, there are our esteemed panelists. We're going to start with recent developments in U.S. federal and state privacy laws and statutes. And so, as you're all aware, this time last year, we were very focused on the California Consumer Privacy Act, given that the effective date was January 1st. Since that time, we have all worked to comply with that law, but have waited to receive implementing regulations from the California Attorney General regarding the California Consumer Privacy Act. The CCPA became enforceable on July 1 of 2020, but we did not see those implementing regulations finalized until August 14th of this year. And on Monday of this week, for those of you who have not noticed or picked up on this, the Attorney General again released a third set of proposed modifications to the text of the CCPA regulations. So a question I have for the panelists this morning is, what are some of the biggest operational impacts of the final implementing regulations? And how have you worked to keep up with the implementing regulations and ensuring that your CCPA compliance program responds to the regulations?
So I'm happy to jump in there. Can you guys hear me okay? Okay, yes. Perfect. I think one of the biggest challenges is the number of notices that are actually required. So you have to, you have your online privacy policy. You've got the just-in-time notice of collection, which is, in addition to your notice, your privacy, online privacy notice, a notice of opt-out, the notice of financial incentives. And so, keeping up with all the notices is a bit of a challenge. You also have to, keep track of your data subject access requests and then publish it on your online policy. You have to maintain your records for 24 months and you have to respond within a certain number of days to do not sell requests. And so you also have to have a training policy and then document who has been, those who are responsible for handling CCPA requests and CCPA compliance, have to have documented training. And so I think that, if you've got rigor around your you just have to, follow the regulations and adapt sort of your policy to what they, to what they are requiring. I think one of the challenges is exactly what you identified, is that they keep changing. You know, when CCPA came out, it was effective as of January, and they didn't start changing the actual act until the September beforehand. So it was really like a 3-month period where we actually knew what the final statute would say. And then the regulations come out after the, you know, the implementation of the actual act. And it's hard to coordinate, you know, to get the details and to do what they want you to do without, you know, having that guidance in place. So I think, I mean, you just have to, you know, keep your eyes on the regulations as they continue to be amended, and make sure that you have a team that, you know, your comprehensive team that is responsible for your data retention, for tracking your requests, for your policies, for your training. Make sure that everybody is informed and that you have a good team that is, you know, helping you stay on track and implementing the regulations, you know, as they are become effective.
Right, great. Karen, any thoughts as well on how we keep up with these changing regulations and ensuring that all of our various business stakeholders are informed and up to date?
Yeah, I'll tell you, that's probably the biggest challenge. One of the things we talk with clients about all the time is we say, you know, and to Faith's point is, you know, with California, you have so many different guidelines that you have to keep up with all the time. But then if you add GDPR on top of that, or PIPEDA on top of that, and Brazil on top of that, it's like, well, how do you now differentiate? So, you know, the guidance we provide is, one, kind of crosswalk and figure out where do you have differences in the regulations and determine what is the most stringent and go with that most stringent regulation, and then pick one. And it might be that for California, your notices have to be more stringent. So then, you know, do you roll that out globally or nationally, where then you don't have to keep changing everything per regulation. Unfortunately, we see, you know, between GDPR and CCPA particularly, that we find oftentimes that, you know, clients are in a situation where they actually have to have differences in their program and how they're handling it. One of the biggest things, and Faith touched on, you know, data subject access requests and individual rights response. That has been one of the biggest challenges we've seen across the board, and managing that process, because you can't fully, anyone who says they've fully automated it is actually not telling you the truth. You can automate pieces of it, but unfortunately it does have a human element to it still. So those are just a few of the things that we think about when we're talking with different companies around the world.
Great, now that's great perspective. So earlier this month, Governor Newsom signed 2 amendments to the CCPA, which ensure that the partial exemptions that are in place, those exemptions pertain to the coverage of business contact information, employee information, are extended, or rather will continue for 1 additional year. And I think that's good news for most businesses, particularly given the challenges of working during the pandemic. And sort of budget priorities, right? Because that additional effort to ensure compliance for employee data is an incredible undertaking. So was that good news from your perspective, Faith?
Definitely. It, you know, it gives you a little bit of breathing room because, you know, like I mentioned, they would, you know, issue the statute and then issue amendments. And you're like, oh, hey, well, do I go or do I wait? Do I go? Do I wait? And then you have the statute and you're waiting for regulations. And then I think what it allows, I think what a lot of companies did is that, you know, from that September to January period of last year, you know, you were sort of scrambling. And then this gives you sort of a little bit of breathing room to kind of go back and, you know, fully sort of review what you've done, refine and tweak all of your processes and your procedures. And you can sort of look at what you did for your previous data streams and then do that more methodically for the B2B and the employee data as they become effective. So it was definitely a welcome change. In addition to a little thing called COVID, which, you know, disrupted business flows as well. You know, it's certainly a welcome change.
Right, and we also see in these amendments that were signed, there was an amendment which provides the CCPA no longer applies to information that's derived from PHI and medical information covered by the California law and other certain information that is de-identified pursuant to HIPAA standards. So we're continuing to see clarifications, reconciliations with federal laws that conflict with California law. And I think, to your point, if we all need more time, and we need more time as we continue to figure out how this law applies to specific types of data that are collected or processed by our businesses. So that's good news. Now, I say that, and I'm going to skip ahead a little bit to slide 7, which is on the California Privacy Rights and Enforcement Act. And while we're grateful for this additional time to figure out how the CCPA applies to our businesses and the data that we collect, we could be thrown one of the biggest curveballs, right, after this November election. And so in California, there is on the ballot the California Privacy Rights and Enforcement Act of 2020, which would further clarify and expand the CCPA and grant significant new rights to consumers and impose additional liability and risks on companies doing business in the state. Some of these proposed requirements include removing that 30-day cure period within California law for non-compliance, and also establish a California Privacy Protection Agency. So I don't know if this means we're going to deal with a mini FTC out of California, but that's sure what it sounds like. The question for the panelists here: if passed, the CPRA will take effect on January 1st, 2023. If so, what changes do you see resulting from the passage of this act? Do we scrap everything that we've done for CCPA compliance?
I don't think you can scrap everything. Well, because, so much that companies have already put in place will roll into kind of how do you manage it going forward. I kind of view, you mentioned, mini FTC. I kind of think of it as like a mini or a replica of the ICO or the Irish DPC, that they're going in that direction. And I think one of the things that companies will need to think about is, thinking through how they dealt with supervisory authorities in Europe if they have to, and mimicking the way they work with, the agency that California is proposing to stand up. And if they do that, then going to the agency early on in the process to say, hey, this is how we handle privacy impact assessments. This is how we handle, data protection impact assessments. This is our process, and maybe talking through it early on will actually help downstream. So just a couple of thoughts I had on that.
Yeah, I totally agree, because this would be one of the first times that a state agency would actually require that you submit something in advance of something going wrong. So usually, you're required to do risk assessments and all other kind of remediation after a big breach. The CPRA would require, a kind of a proactive annual risk assessment process and data impact assessments, for certain things proactively. And perhaps by having that proactive measure, like Karen mentioned, would give both companies, and the regulators sort of more comfort in kind of what's going on and giving direction in advance of, a slap on the hand. So, more preventative than corrective. Right. That's great. So not only do we have the CPRA to consider, but there are various CCPA copycat laws that have been proposed, and we're actually on track to be passed and effective as of the beginning of next year or of 2022. But then COVID happened, and so many of these laws have been pushed. But maybe Karen, could you speak to what you've seen in these proposed statutes, as well as the proposed Safe Data Bill, which is a federal law that is being put forth in Congress?
Yeah, it's funny. COVID did it kind of stopped a lot of these acts in laws in their tracks a little bit, you know, and I think they will start to resurface here over the next several months and maybe even get some traction early next year. You know, New York obviously has taken lots of steps in terms of, you know, the New York DFS, the Department of Financial Services, who has, you know, their Data Protection Act, and, you know, you've got the SHIELD Act, which I know we're going to talk about in a minute. I mean, New York has been pretty progressive. Surprisingly, New Jersey has been trying to pass a law as well. And I believe Connecticut has a law out there, and obviously you can see the ones we have on the screen here. I think the biggest thing is going to be is companies, if they can think through how can we satisfy giving data subjects or individuals access to their information to be able to, whether it's correction or deletion, but even knowing what kinds of information they're collecting about the consumer, they're going to be 10 steps ahead when all of these acts go into law. So, you know, that's been the one area we've seen has been the biggest challenge. The other thing is around policies, and Faith is probably going to laugh at this, but when you write a policy and you put a policy out there, if that policy, if you're not following that policy, you're better off not even having the policy. So probably, you know, thinking through those types of things of, if we say this, then we need to do this. And if we're not doing this, then, you know, we need to take a good look at our practices. And operationalizing privacy programs, you know, again, you cannot continue to look at them across the board and say every single individual law has to be met in a different way. You have to think about it in this holistic manner, or else you're going to drive yourselves crazy, at least from what we've seen. And so when you do take a step back, you know, and you say, well, you know, you're going to have, you know, eventually I think there will be a federal law. I don't know when, I don't know how soon. I mean, we keep predicting that it's possible it'll come in the next couple of years, but it's hard to say. I think when so many states, you know, it was kind of like with the data breach notification, all 50 states now have data breach notification requirements. Well, we're moving in that direction where I think when the majority of states are putting laws out there or trying to pass a law for privacy, it's going to move in that direction of the federal law.
Right, great. And I think we're also seeing that with respect to data security laws and statutes, right? And so this year we saw come into effect the New York Stop Hacks and Improve Electronic Data Security Act, the SHIELD Act. And I guess I have a question for Susan, who focuses on security. You know, did the New York SHIELD Act have any impact on the security frameworks that you're following, or do you view it as its requirement in following industry standard frameworks, such that if an organization is already, you know, compliant with SOC 2 or an ISO standard, you're in good shape when it comes to the SHIELD Act?
Yeah, thank you for the question, Bess. I think adding to Karen's earlier point about, you know, the importance of understanding your data assets and where they are, and, you know, the end-to-end flow of that information, you are a step ahead. That essentially is foundational to understand where your security controls need to be applied. I think PCI and SOC audits are good. They provide us with some type of framework to begin that work. When you look at, so in the security world, we always work to strike a balance between security and compliance, right? And focusing on security, understanding your assets, what are some of the critical controls that you need to have put in place, that would essentially lead you to a path of compliance. And I think the priorities may be different depending on the organization and the nature of their business. But I think if you started your journey in understanding what is it that you're looking to protect and applying the right level of controls to those assets in terms of being able to proactively identify the assets, where they're located, putting preventative controls in place, as well as controls to monitor the ongoing movement of those assets, you are way ahead.
And Bess, there's one thing that I just wanted to mention about the SHIELD Act that I think is really interesting, and be curious to see how other states kind of evolve their security legislation, is that the SHIELD Act does not apply to healthcare data. There's an exemption. It applies to, that data that really is financial data for the most part. But what it does say is that if you are a healthcare entity and you report to OCR a breach, you also have to report to New York. So while it doesn't necessarily regulate healthcare data, there is that sort of backdoor requirement that if you've done something wrong, that you do have to notify that New York health agency. And that was the first, kind of state law that we saw with that kind of component. Usually it either regulates healthcare data or it doesn't. And this was one of those interesting times where it does not directly regulate healthcare data, but it does require that if you report a breach, that you report into that New York agency.
That's a great point, Faith, and it's something to watch as we see other states pass similar legislation. I want to be cognizant of time here. We're already at 11:40, so we've just been having a lot of fun discussing all these privacy laws and regulations. I hope our audience is enjoying this as well, but let's move on to the Schrems II decision. So again, I was going to have a poll to ask the audience, how many of you are dealing with the invalidation of the Privacy Shield framework? And perhaps we can, I see we have a notice about questions, but I'll ignore that. Oh, here we go. Okay, great. We have a poll. All right. So did the recent decision to invalidate the EU Privacy Shield and Schrems II impact your business? Yes or no? And if you don't know what Schrems II is, let us know that as well. So we'll give everyone about 10 seconds to complete the poll and submit and see the results. All right. So it looks like we have 33% of the audience, Schrems II decision impacted their business, about 13% it did not, and 53% say, what is Schrems II? So that's all right. I can break that down for you. The GDPR, the European General Data Protection Regulation, which governs the collection and processing of European Union resident personal data, sets forth a prohibition on the transfer of that information to countries that the European Commission deems not to have adequate data protection laws. The European Commission has found that the United States of America does not have adequate data protection laws. We have no federal scheme. We have a legal process that permits discovery and access to business information through the litigation and the investigatory process as well through the use of a subpoena. So as a result of that prohibition, there was in place a treaty between the United States and the European Union, which permitted the transfer of this data from Europe to American businesses if American businesses were to obtain a certification and apply for a certification through the U.S. Department of Commerce, which said they protected data in a certain way, and they would be subject to discipline and would engage in arbitration, for example, if a European resident were to complain about how an American business was using their data. So we've had this framework for a while. It was preceded by another framework known as Safe Harbor, which was also invalidated several years ago. But the European Court of Justice invalidated or said essentially in this decision that the Privacy Shield was not sufficient and affirmed the use of another tool for the legal transfer of data known as the standard contractual clauses, which is a contractual agreement between business entities. That as a result of this, as you might imagine, businesses who are operating or doing business in Europe or processing data on behalf of European-based entities, many of them relied upon the Privacy Shield framework in order to conduct legal transfers. So that's Privacy Shield 101. So the Schrems 2 decision came down this summer, and while we knew it was the Privacy Shield was being criticized and its legitimacy was involved in litigation, we didn't know when the decision would be announced, and it happened this summer. So question for the panelists, how do we handle this decision? What do we do? Do we scramble and put in place standard contractual clauses? Do we wait and see if the U.S. Department of Commerce negotiates a new treaty with the European Union in order to permit the legal transfer of data? What advice do you have for the audience?
So, I would recommend that you definitely, if you relied on Privacy Shield to transfer information from the EU to the US, even if you just have employee information, even if you don't have customers, employee information is another way, another reason why a company would transfer for centralization of HR processes, that you have to do standard contractual clauses. If you're transferring to the US, that is the only option unless you have binding corporate rules, which is another long discussion. And if you don't have them now, you certainly won't have them quickly. So that's not even an option. So I think you do. The challenge, however, is that I understand that the European board is going to release a new template for standard contractual clauses that are expected around the end of the year. So right now, there is no grace period. So if you had Privacy Shield, you have to immediately switch to standard contractual clauses, which is a template, but the template is going to change by the end of the year. So I'm not quite sure what advice to give companies. Technically, yes, you should change to standard contractual clauses now. But if you know that you've got to redo, because they didn't talk about a grandfathering of agreements that are already in place, they just talked about issuing a new template. You need to think about, do you make those changes now and then potentially again in January? So I don't know if I have really good advice, but just some perspective.
It's funny you say that, Faith, because I was thinking the same thing. I'm like, it's kind of like, well, what do we do? And, if you look at Berlin's even saying, hey, standard contractual clauses are not sufficient. Now you can still use them, but they're not happy about that in Germany. So, there's a big balancing act here, and it does seem like a great point on the binding corporate rules. I was thinking back to companies that have filed, and it's been 3 years, and they're still trying to get them passed and approved, and it just takes so long. So to your point, binding corporate rules are a tough way to go if you haven't started the process.
That's right. That's right. So the answer is there's no good answer at the moment, but certainly take a look at an alternative legal transfer mechanism and consult what data protection authorities are saying in the individual member states, because to Karen's point, some member states are taking a much more strict approach here. So let's shift gears. We have about 5 minutes before we go into questions, and I really want to get Susan's perspective on some of the security approaches that she has in mind and has been taking and implementing in light of the shift to remote work. So obviously, with the shift to remote work, there has been an increase in cybersecurity risks, right? And really, it's been very difficult for both IT and information security groups within our organizations to keep up, and understandably so. Maybe, Susan, if you don't mind, walking us through some of the risks related to a remote workforce that you're seeing and ways that you've addressed some of those risks. And then I'd also like to hear from Susan and yourself, or rather Karen and yourself, about some of the types of cyber attacks that we're now seeing as a result of this shift to remote work.
Sure. Thank you for jumping to this slide. I think it's always, really fun to talk about security and, what we may be able to do to better secure our environment. So the deviation to remote working really means that organizations are really opening up and extending their traditional corporate boundaries to home networks. So if you think about, from a threat actor's perspective, this means their attack surface area has been significantly increased. And it is now easier to influence insiders to make mistakes. So I think with that in mind, organizations should really consider reminding their employees that they're not in a safe shell where all the necessary protections are in place to protect them. And an organization should also reimagine the type of security awareness training that they should provide to their employees. Providing education on the use of VPNs when connecting remotely, encrypting emails, and use of personal devices can be, a really good starting point to counteract the newly introduced factors of remote work environment. And also putting mechanisms in place to have assessments to test that employees are taking the appropriate actions for their various environments and scenarios would be very helpful.
Yeah,
Great.
and we were talking about before we came on for the panel, I was mentioning how one of our clients had a pretty big ransomware attack over the weekend and literally shut down everything. And it was all due to multi-factor authentication not being implemented on one of their systems, and it literally crippled the company. And I think it was a nonprofit. So, the multi-factor authentication, the encryption, I mean, especially if you're dealing with healthcare and credit card information, I mean, ensuring that, you are securing that company information because, ransomware and phishing have spiked drastically since the beginning of the pandemic. And, your IT and security teams really need to be doing as much as possible to protect really that personal information and ensuring that individuals are not being put at risk.
Mm-hmm. Yeah, and also fundamental to kind of knowing your environment is being able to identify the hotspots, the groups of employees that may be able to do the most damage, and tailor cybersecurity risk mitigation efforts around that. And everything goes back to access, right? So having least privileged access and effectively logging and monitoring that access would be another mechanism that can help greatly, enhance you being able to gain visibility into your environment.
That's right. And those access control concerns also come into play when we think about, I'm just going to move through here the slides. When we think about our pandemic response, right? And as we think about, complying with the laws and various guidance that's been issued around the collection of certain health information and, health status information that we're now collecting about our employees. Who has access to that? How long do we need to retain that information? We've seen various data protection authorities issue guidance on these issues in Europe. We also need to think about, as we reintroduce the workforce into the office, what happens to the data that's been kept at home, right? Or how much control do we have over the data that's been kept in home? So any thoughts there, Karen?
Yeah, I mean, we see this a lot too. So, everybody's using Teams and Zoom and those types of things. We had a situation early in the pandemic, and it was a video conference, and the client, somebody from the client brought up a spreadsheet of all payment card information that they had and started scrolling through it. And so one, you had your access control issue there because they could export a list of all credit cards tied to the individuals, and it was hundreds and hundreds of thousands of rows. Two, you had the issue with somebody bringing that up on the screen, which is a big no-no because anybody could take a picture of that, use those credit cards. You don't know And then you have to think about some of these environments that have been hacked over the last several months. And, you know, you have to think about, are you really putting governance mechanisms in place? So the information that's being kept at home, you know, if they're not using a work computer, that's where it can be really problematic. If they can download things to their devices, you have the same problem that you always have. You had that before the pandemic. So really putting in the proper measures, one, to have some governance around your video conferencing, making sure that employees are trained, ensuring that people aren't, you know, just clicking on the fake CDC information website or emails they get, because that's been rampant. Or, hey, we have a great way to help you, you know, get through COVID, and it goes to your work email. You probably didn't ask for that, so just delete it or put it in the junk folder. So thinking through those things, it's really around that governance and management and ensuring that, you know, you're taking an extra step. And if people are using home computers, there does need to be some type of steps. You need to put some steps in place to ensure that you can protect that information and that it's not going to go to Johnny down the hall who's 12 years old and all of a sudden has access to all of your corporate information. Hey, Bess, I did want to tell you we have a number of questions. We have, I think, three or four questions.
Yeah, I was just going to say we should move on. We should move on to questions. So we have about 5 minutes left, and I see 3 questions here, and we'll try and tackle all of them quickly. So maybe this is for you, Susan, but also for Faith and Karen. Have you seen any issues with privacy or security concerns around company information that might be in the background of video conferences, right? Or exposed on a table, right, within view? And if so, how do you address that, or how have you advised others to address it?
Yeah, that's a great question. It's kind of interesting because when I was thinking through this conference here, this discussion, you know, I thought through that a lot of the policies is essentially re-educating of our associates on our company policies, right? What applies at work should also apply at home. So for example, not displaying confidential information is something that a lot of organizations would stress with their employees. So at the office, please do not post a network diagram behind you when you're doing video conferencing, and just a bad practice in general, right? So please don't do the same when you're at home. Be cognizant of what you're posting. When you're essentially making sure that you are securing the confidential information, including in a physical form around your workspace.
Yeah, I couldn't agree more.
Go ahead, Faith.
I couldn't agree more. I mean, we did, you know, campaign video vignettes of people having a birthday party in a conference room with confidential information on the blackboard behind them, just as a teaching mechanism. So I don't think the pandemic sort of changes that. You know, like Susan said, you just need to reinforce some of those things that you've already put in place, hopefully, with your employee base.
Yeah. Well, and, you know, I find it's not so much about what they're posting behind them or that you see on the video. I find that there's a lot of people who don't have closed doors. So there's not that confidentiality. And, you know, if there's, you know, the spouses are working at home and kids are around, or the kids have groups over, you know, for maybe some of their, classes or studying or something, you still have to be cognizant. And we take extra care from my team because and Beth, you're probably the same way, where we're working across with so many companies that we can't just have conversations out in the open with them.
That's right. Great point. So what type of disciplinary action are you all enforcing when there are repeated failures by employees in phishing attempts, right? And this is never good to be susceptible to a phishing attempt or to commit a fraudulent transfer. But what types of discipline are your companies engaging in, or would you recommend?
Retraining is definitely one. So when you have clicked on a phishing exercise, particularly internally, we prompt them to try to, you know, educate folks, and you are invited to take some mandatory training once you have clicked on one of those. But I think, constant education and training is certainly helpful.
Great. So one final question, and then we'll wrap up, and that is, who within a corporation should be monitoring all of the new CCPA updates? Should it be the compliance team? Should it be legal counsel, governance and risk? Who is best suited to monitor those developments?
I'll chime in and just say, we really see the data protection now being driven out of the compliance office or the legal office. And this was across the board for companies really large and really moderate sized. So we're seeing that mostly. We're also seeing a lot more, I would call them data protection committees. They started as data governance committees, then they became cybersecurity committees and privacy committees, and now kind of overall data protection, where they're bringing, the people responsible for PR, marketing, sales, security, privacy, legal, bringing them all together. But I have to say, I am typically seeing this come out of the legal team, mostly over the last, I don't know, probably 18 months or so, which it's a good place for it.
Yeah, I would agree. I think the legal team, they're the ones that are driving the awareness and the requirements. I think it's your compliance team that is driving the your compliance and your security team are driving the operation, the implementation of it. But I think in terms of monitoring the changes and the updates and the actual legal requirements, primarily should come out of legal, at least how I've seen it. It varies by company, because sometimes you have to look at how your company has kind of, what their structure is and how they have been operating, because it's certainly not a one size fits all. But I do think I have typically seen the requirements coming out of the legal department.
Great. Okay, well, that concludes our presentation. Thank you for your questions and your attention during this hour. We really appreciate the opportunity to speak with you on these issues. If you have any questions, please let us know. You can reach out to us individually or reach out to your ACE contact to obtain our contact information.